different things I'm picking. If Ruto was insincere, he wouldn't want a deputy president. Come to think of it, he wouldn't want a deputy president. If Ruto was not sincere, he would be trying to find angles and, legal interpretations that allow him to be the one at the helm without a deputy. But what did he do instead? He has moved quickly to shore up that gap and that vacuum by nominating a man that he feels he knows well and trusts and that he can work with. Because it would be another story now if, like in the VP Saitoti days, God rest his soul, Moy went out of VP for a long time, and when people asked, he said it's not important because it doesn't add an extra sufuria of ugali on your table. So, for me, in all this, Ruto is not suspect. What my sense is, my feeling, Ken, is that there's a huge agenda for the government. There's huge expectations. There's many, many, many challenges. A lot of projects have stalled. There's fiscal issues within government, the delicate relationship with IMF, and on loans because of the borrowing that happened under Uhuru. That's just a fact. And so, if you're working at cross purposes, it can never work. That's just my feeling that if you're working at cross purposes, that can just really never work. And so, maybe the last point I'd like to make is, the lawyer Duncan, the other Duncan Okach, who was explaining that the High Court order was a reversal. A conservative order is a freeze. Like there was a whole elaborate process, and now the order, the court came in and looked at what was happening and listened to the pleadings and said, okay, wait a minute, let's just pause. Let us freeze the process at this point so we can make an evaluation and then we'll revisit. That's my understanding. There's nothing here like vacating or overturning. It's not the same thing as what happened in 2017 when the Supreme Court looked at the evidence, numbers were not adding up, said that there were issues and irregularities and illegalities and process issues, and then overturned the result. That's different. That's at the Supreme Court level. At this level here, as a conservative order just says, okay, let's just hold on a second. Let's pause. Let's take a look. Let me hear the parties, inter parties, for instance, and then we will make a summary judgment. A summary judgment which then can still be appealed in the Court of Appeal. Again, I've warned about this country becoming an overly legalistic society where there's so much legalese under this Constitution 2010. Anybody and everybody can go to court for anything. So I urge caution. I urge that we try to be very objective and always to unite the country to avoid, anarchy. But I also must express my reservations on why the former deputy president just wants to cling to office by force. It's that, Ken, if maybe you could help me understand, that has never made any sense to me. The minute it's dysfunctional, things are not working. This is a political office. Inside of a political process, you guys are in a party, UDA, Kenya Kwanza Coalition. You feel a certain way about Mudavadi's so-called shares or whatever, you're unwanted. And you yourself, let us not also argue in the context of defending the constitution. A lot of people who are defending it, they're kind of making Rigathi Gachagua look innocent. Gachagua is not innocent. Gachagua is a tribalist. Gachagua is toxic. He's been, and repeatedly, he's been advocating against other communities. In fact, I just saw video earlier today where I was just looking to see what we will discuss on this show this evening, Ken. A video of Gachagua just lambasting the former prime minister in front of the president, using unpalatable language and actually issuing threats during finance bill, saying that parts that did not vote for the finance bill or that expressed dissatisfaction with the bill shouldn't have roads. I mean, I think he just never read the Constitution. I've said this and I'll say it again. Gashagwa never understood the Constitution of Kenya 2010. There's no way you can tell me a deputy president can stand on a platform and say that there are people in Kenya who have no shares. That is unforgivable. I don't even know how he survived 2 months after making such a statement and went further to make the statement again, including in vernacular and in Swahili. So it's not like he's innocent. We reached this point because Gashagwa made his bed and then he lay in it. The process went through the National Assembly, it went through the Senate. Those are just statements of fact. What I'm surprised is that a judge had the temerity to rush to stop such a, a, a delicate and weighty process. Perhaps I might concede that it looked a bit high speed. Maybe it could have waited a day or two. But then again, here's a situation, Ken, where Gashagwa's own legal team concedes an hour after they've broken for lunch that they don't know where he is. Doesn't that smack of trickery to you? That's what Muita said. We're trying to get a hold of him. We don't know where he is. And then you expect me to just believe that he's unwell and admitted in hospital? Come on. Mchezo wa tauni. Asante.
Asante Benji. Um, I see our time. We have about some few minutes with this. We have had a lot of discussions on this. Um, Professor Ochieng Odongo, perhaps take 2 minutes, then Joe Asali, then Dan Chapter, then we can close this for tonight. Let me see how many more people want to join, but let's go with Ochieng Odongo, just about 2 minutes, Joe
Thank you.
Asali, and then we can give back.
Thank you so much. Thank you so
Yeah.
much, Ken. I think mine would even probably take less than 2 minutes. I just wanted us to be a bit more objective. I know, this issue has elicited a lot of reactions from the public. Some of us, of course, have a stand. Some of us don't like Gachagua. Some of us like him. But on matters such as these, I think the most important thing is to let the Constitution have its way. So if somebody then comes and begin to say that, there were those orders from the court, but because you want to cite so many things, then Kindiki is a president. I don't know, deputy president elect, and Gashagwa is not. Is not a DP. Is not a DP. I think that is misleading Kenyans. So I think the focus should be this. Where we find ourselves now is it's a situation where which according to me is very simple and that is very basic, because when the courts have spoken, whether you like whatever it is that they are speaking to or not, ours is to comply. And to this level, therefore, the courts have not even said if the process were not followed or not. What they have done is to issue those, what we call those consultatory orders. And I was talking to a lawyer friend of mine, and what lawyers say is that, consultatory orders are not just mere injunctions. They are even different from stay orders, so that they are very comprehensive enough to the extent that they can actually even stop things which are yet to happen in the future. They can also then stop things which have happened. So to that extent, therefore, we have Gashagwa as our DP. It is not something that most of us like, but that's the reality. So, it is also important to note that where it is now, Tuesday is not very far. That is when then we should be able to know what the courts will then say. But if we try to act with emotions and probably try to bulldoze the courts, some of these things will be used in the future. And courts are very, very, very interesting people, because what happens is that a judgment that is passed today, if it is bulldozed through emotions and whatnot, it can then be cited next time. And that next time it will be a Ken Mijungu that is the DP in question. So let us just have and let the courts and the judges do their work. Thank you.
Can I had a right of reply?
Yes, Dan, can you have would you want Joe Asali to go? Then you can have your right of reply. Okay, Joe Asali. Thank you, Professor Ochengo Dogo. Asali? Oh, he's not here. So Dan Chapter, are you here?
Yes, can you hear me?
Yes,
Yes,
go
I'm
ahead.
here.
We can hear you. Go ahead.
Oh, I think by now we have a
Yes, go
big
ahead
problem.
then.
Can you hear me? Can you hear me?
Yeah, but your network is not clear. You're breaking.
Okay, but you can hear me now.
Yes, we can.
Okay, what I'm trying to say now is this: in Kenya politics, it's very difficult to decide between today or tomorrow. We have to give it time because if we keep trusting God, God will never work in Kenya. Uh, politics are Politicians are the one who are arranging what is happening in Kenya. Now we have a big problem. William Ruto control everything, controls the courts, control the police. As a country, we only have Ruto. Now he has a big part to play. We don't have anything to do with judiciary. Kashako is going now. Kindik is coming. Kindik cannot say anything. We don't have deputy president. We only have William Ruto. Everything is William Ruto. That's what I can say by now.
Okay. That's it. Okay. Um, that's it. Okay. So, Joe, are you here? Joe? Joe is not here. So Dan, you can go with your right of response. Then we can see when to end this. I more people are tuning in. I don't even know if some are just coming in and we are tuning out. But Okach, it's your time now. Anyone who can hear me?
Can you hear me? Hello?
We can hear you. I think the host is the one that may have an issue because we can't hear him. Or the host has been impeached.
Tunaingia vijijini, mijini na hata jijini kukuletea taarifa mchana kutwa. Usiku tunakaa kitako, tunadadavua tukichanganua taarifa na makala muhimu yanayokuhusu wewe na familia yako.
Nasikia watu wanasema baba ametusaliti. Between baba kutusaliti na sisi kusaliti baba, nani amesaliti mwingine?
Inapeangwa, it mostly goes to foreign ministries. So Baba is overqualified for that position.
To build this railways for Africa. So now he's thinking about tumemkataa kama baba wetu.
Unaweza kuwa kuna mtoto ulizaa, ukapatia nchi, ikuwe inamfanya vile inataka.
Uhuru has been working very hard. Ruto akaenda huko na nguvu. Ruto was never invited in the inauguration.
Ungana na Bernard Ngozi kwenye Open Forum Political Show kuanzia saa 4 usiku hadi dakika zake kila siku ya wiki kwenye Candid Talk.
Open Forum Political Discussion Show. The show that gives you an opportunity to air what you feel and think about the latest development.
Tukutane Candid Talk.
Like we are anyone who is saying that Honorable
watch,
Gachagua is
share, like, subscribe,
Gachagua or his utterances, or a lot of things that he was doing. It's very far from that. The moment you see us saying that indeed he is the deputy president, it is simply because we are aligning ourselves with the constitution. What we love is not Gachagua, but we love the constitution, we love the law, and we believe that the rule of law is very important. And I think Professor spoke very well and very fluidly, and it was quite good, because it is about the law, it's not about the person, and it can be him today, Gachagua, tomorrow it can be another person. More importantly, it is about what the courts have said. It is not about any other issue surrounding how fluid other issues are. It is what the courts have said, and the courts have not had their last word on this matter. The courts will still resume on Tuesday, and they might give further directions. That must be complied with. So it is not an issue of the way, of course, I had, of course, Benji, and many people, Kenyans, and not only Benji, many people have their reservations.
Watch, share, like, subscribe.
Those are very bad. Somebody can say what Ndolo was trying to allude of sharp practice, where, for example, you're in the Senate.
Nomination, any processing of names in parliament, it does not matter. So that this is exactly what has happened to Kawera Mwangaza. That's why she's governor. It's exactly what has happened to Wambora in his first and his second tenure, and he remained governor. And the same thing is happening. The only difference here is the fact that there was a name to replace. But to that extent, you see, for a governor, the name to replace is always there. It's automatic, except for even the Nairobi situation where the deputy governor had not been processed. But for all this, like in Meru, it will have been an automatic issue. However, you see, the fact that the courts have issued conservatory orders, also accompanied by specific orders preventing the nominee, that is Professor Kithure Kindiki, from being sworn in, it then means you cannot have an argument logically of saying that we have two deputy presidents. Actually, it is a fallacy from the word go. And anyone saying that should look at the Constitution. It's very clear. And even not even our Constitution, even other jurisdictions like America, for a president is actually elected and a deputy, but they assume office at the time that the Constitution has indicated. So that in between you become a president-elect, deputy president-elect. So even at this point, once you are just deputy president or president-elect, it does not mean you are a president. It is qualified. So someone cannot say that you are until you take that oath of office. And for this particular seat, there are two oaths that must be administered in a structured manner, structured by the law. So that question of saying whether we have, whether Rigathi Gachagua is the deputy president should not even be there. And it is the easiest thing to clarify based on the law. And that's why even for whatever is to happen tomorrow, or even at this particular point, Rigathi Gachagua retains all privileges and powers of that particular office until maybe this court varies its orders come Tuesday and allows for a swearing in. That is the only position. But as of now, there should be no question in law of whether or not we have a deputy president in the name of Rigathi Gachagua.
Duncan, tell me something. When the orders that were issued from Kerugoya state the implementation of the resolution from the Senate, right? When they state the implementation of that resolution, what did that mean?
Ken, the orders that were issued from the orders that stayed the implementation, first of all, was from Nairobi, from Justice Chacha Mwita. Those were the first orders that came. And those were in the nature of a conservatory order, even protecting and specifically saying there should be no steps in terms of replacing Rigathi Gachagua. When there was that conundrum, whether it has been overtaken by events or not, the court sitting in Kerugoya, that is Justice Mongo, issued orders which were very specific, now targeting Kithure Kindiki, Professor, and indicating that Professor cannot take over, that office cannot be sworn in, and it was so specific. It actually gave more clarity in terms of these particular orders of Justice Chacha Mwita. So the effect is that any attempt or anything suggesting that the deputy president in the name of Rigathi Gachagua has gone home is null and void. It actually maintained what we in law we call the status quo ante. It reverses to where it was and says that the position that was remains until we determine this matter or until we give further directions. Ken?
There's a lot. Sorry, there's a lot of
Ken,
contention.
Ken.
Yes, Benji.
Point of order.
Benji.
Yes, point of order. Good evening, everyone. You can hear me?
Yes, loud and clear.
Asante, the issue is so sensitive. I actually wanted to listen a bit before I jump in, but the issue is so delicate that I have to jump in. And maybe just to kind of temper how delicate this is, allow me to just say a quick thank you to everyone that's tuned in. A quick shout out to my friend Nonini, who I think is in Seattle. All these different guys who are participating. You know, it's a participatory democracy. People who are not necessarily politicians and are just interested in the conversation. Just to say you guys are doing the right thing. Catherine Irungo, I see you. Sir Alvin, Paul Kamau, Apollo, Fwamba, my old friend Fwamba nakuona hapo sana. Sasa, Ken, I think Duncan is taking the issue a bit lightly because, and here I'm speaking as a layman, a plain reading of Article 148. Let me just guide the audience. I've been teaching people to read the Constitution during this time. That's civic education. Article 148, 6C. And let's remember this is a plain reading of the Constitution in black and white. As prescribed in the third schedule, the term of office of the Deputy President shall run from the date of the swearing in of the Deputy President and shall end, so there is A, when the next Deputy President or President is elected, B, on the Deputy President assuming office of President, all right? Or C, on resignation, death, or removal from office. Rigathi Gachagua was removed from office in a procedural fashion by the pronouncements of the National Assembly and subsequently the Senate of the Republic of Kenya. Whether you think there were interest in that or orders or anything that anybody thinks, the fact is that the removal happened in broad day or nightlight. And I know because I was on air during this removal. At that point, therefore, it is erroneous, number one, even from a sense of decency, for a court to injunct, an arm of government that is doing its constitutional work transparently, or two, to purport to overturn a, a, a process that has happened constitutionally. In other words, the process of the removal of the deputy president began appropriately when a petitioner filed charges that were listened to in the National Assembly, that were then voted and met the threshold, and the National Assembly then transmitted that result to the Senate, upon which the Speaker of the Senate received the same, began the trial. The accused, all right, opted out of trial midway, gave whatever explanation he gave, asserted that he was not feeling well. An hour before, he was laughing. And then we went ahead to electronic voting that was transparent and verifiable. And then the removal happened. That removal actually happened because I took notes here. On the 17th of October at 11:33 p.m. after the houses or this particular house has sat Ken for more than 12 hours. So whichever side of the debate you're on, it would be reckless. This whole discussion, we shouldn't entertain a discussion of, oh, Kenya has two deputy presidents or anything like that. Rigathi Gachagua ceased to be deputy president. In my own humble opinion, any court rushing to injunct that is being reckless. Of course, judges can, I'm not a judge, and judges can do what judges do, but judicial restraint and judicial responsibility is something that has to become our culture and based on jurisprudence, so that the fact that the accused has even been forum shopping, and that's just a fact. That he has filed, frivolous lawsuits all over the place. I think 23 in number. That's bothersome. That's bothersome. I mean, I'm sure later in the show we'll talk about the practicality of how to work within the presidency, because I don't even see, for discussion of purpose, how a deputy president that cannot work with his boss will come and work by force using a court order. It has never made sense with governors. It cannot make sense in the presidency. And so, in a sense, it's futile. I think what it's going to do is delay the inevitable. Professor Kindiki has been nominated by the president. The president has powers. We must also understand the presidency. And I am the last person to argue for an imperial presidency.
Benji, I have a problem with you. What you're
Ken,
talking
one
about
second.
no. You presupposes that we should not allow other people to speak their mind. That is what you're trying to tell us.
Who am I curtailing from speaking their mind?
Like Duncan Okach, you don't want Duncan Okach to speak his mind. You can counter
I don't want him to mislead Kenyans.
allow him. You have to allow
There's
him.
a lot of propaganda going around. We don't want to propagate confusion on this show or any show. The removal happened. Okach was in Kenya or wherever he was when this happened. The removal happened.
Benji, let's be respectful. I will not say that by propagating your mind or what you think, you are misleading. That is your view. Let me also give Kenyans and the listeners my mind. Let them make a decision. Let us convince. Listen. Let us convince them. I will give them my position, and I will use proof. You give them your position, use proof,
I hear
and
you.
maybe
Duncan,
you might convince
it's
me.
Not an
you
attack.
Never know.
That's why I started with a plain reading of the Constitution. And remember, this is a sensitive matter, Wakili. All I'm saying is, actually today I've received very many phone calls from all around the country, and a lot of wananchi have not, like you and I, read the Constitution. So what I'm saying is that if we're not very careful with our
I have read the
Constitution.
I have read the Constitution. I'm a lawyer. I'm not just
That's why I said
writing
you and I have read the
for the sake of
Constitution.
it. So don't say.
I said you and I have
I thought
read
you
the
said we have
Constitution.
not.
I will guide Duncan and Benji. You're both my friends. Dr. Duncan Ojwang is here. I'd like to guide the conversation. We are going to allow people to speak their mind, but let's be respectful, because this again is a sensitive issue and a lot of Kenyans are listening to us. So Benji, you're my friend, but order. You have to allow people to speak their mind, then you counter them. And there's so many lawyers joining this conversation. I see even government officials are asking me to make them speakers. So let's allow everyone to ventilate. Leonie weekend,
Ken, I was just clarifying.
Yes, Benji.
Ken, I was just clarifying, and I'm about to just take a back seat so people can speak.
Yes.
I was just clarifying, as a strategist, as an analyst, I was giving a plain reading of the Constitution, because one of the risks that we run is that all different lawyers are coming with all different interpretations, and there are all manner of interests, and there's all manner of teams of lawyers. I mean, the deputy president is led by none other than senior counsel Paul Muite. And so if we are not careful with how we frame the discussion, I was just, from my own experience, understanding and working, understanding the presidency, I was just contextualizing, for instance, the practicalities of how government actually works, what the president can do and what the president cannot do. For instance, the president did not fire Rigathi Gachagua at 1 o'clock the way His Excellency Daniel Toroitich Arap Moi used to do. These are just facts. So the president cannot pick the phone and ask the deputy president not to report to office anymore, or call a media house and announce the firing. So what I'm explaining is that on a plain reading of the Constitution, all right, under Article 148(6)(c, this is just one article, and there are other articles that we can use to interrogate this further. A deputy president ceases to hold office upon resignation, death, or removal. So we witnessed a removal from office. There has been a court process to, raise all manner of issues in a high court, not even in the Supreme Court. And the president has gone ahead and made his nomination of a deputy president, which has then also been forwarded to the Senate and communicated in public. Now, it is just not fair for an educated person, with everything being what it is, to then utter the words that Rigathi Gachagua is a deputy president, because he's not. That's all I'm saying. No prejudice.
Right of reply.
Ken.
Ken, you are muted. You're on the other.
Oh,
Yeah,
sorry. I have said so much. So I said,
so
Duncan Ojwang, I'm giving you the mic next, but Duncan Okachi was speaking. I think you deserve the right to rebut what Benji has said. Then I can open also to Dr. Duncan Ojwang to give us his perspective. And we want to welcome everyone else who has joined. Today we're discussing about politics and of course the judiciary, what's happening in the country. There's something that happened last week. The deputy president was impeached. The court gave an injunction, and the government has complied. And tonight, I'd want just to say that this is the first major blow in this process to make or to now have Kindiki as the deputy president. The first major blow tonight. So there's a lot to discuss. But let me get back to Okachi. Then we can move on to now laying the ground for the whole discussion. Duncan?
Yeah, thank you so much, Ken. I respect Benji's views. And to that extent, I would want to indicate that the position of the law is that courts have ultimate powers to even correct anything that has been done, even by the president or the legislature. That is why, if anyone will look at the clip where Justice Ogola heading the 3-judge bench with Justice Mrema and Justice Frida Mugambi, when they were asked to issue orders in anticipation, they actually said, don't worry, let the Senate do what it will do. If there's any rush, because there was a request to have a mention on Friday, if no matter what happens on Friday, we will have the power to actually reverse anything that happens. And that was a commitment by the courts. Unless someone is saying now our courts do not have the power, because these courts have actually undone what the president has done many a times. And that has not started with this particular presidency. And that is a power that Kenyans conferred upon the courts. So that even if you read the constitution and it tells you this person ceases to hold power upon removal, and then you juxtapose it with the orders both from Nairobi or from Kerugoya, you'll see that the orders are so clear that it actually conserves, it actually prevents anything from happening, and it actually even reverses, it acts, retrospectively. So a court has already issued an order. Can we now start arguing with the court that no, you are wrong, you are right? That is an argument that you can persuade the court when it sits next week. If you look at the documents filed by the government, that the Attorney General, that is what they're trying to persuade the court. Kindly, we respect your order. We respect the fact that you have the right and the power to stop any process. But kindly, because of reasons 1, 2, 3, let us proceed. That is the argument that anyone would have. But when you go to court and you try to tell the court, what are you smoking up there? Why did you issue? Then you are challenging the ultimate power given to the court by Kenyans themselves as the last bastion that protects any Kenyan. And let me tell you, and Dr. Ojwang will speak my namesake here, the courts have the power, and they've done it many times, even in normal employment matters. Someone is dismissed, and the courts have reinstated. It is normal. You have seen even the current Nairobi University guy. He was his employment was interfered with by the former education cabinet secretary. Now again, there's an issue. He's gone to court. It can be reinstated. So the courts have the power to reinstate, and that is what they have said. And remember, they have not yet made a decision on whether the impeachment was right or wrong, like now where Benji is going into. That is a determination that will be made in the fullness of time. But they are saying, before we make that determination, it will be unfair to be making a determination and someone is already suffering. What if we make a determination and this person, we find that the process was wrong.
Okay.
It is important to conserve.
Okay.
But the court, as I finish, the court can as well make a decision and say, no, you can stay outside. We will make a decision and maybe compensate you in terms of monetary terms. But that is the power of the court with their wisdom. And this is something that can be appealed all the way to the Supreme Court.
Okay, Dan, stick around, stay with us. Dr. Duncan Ojwang, thank you for joining us tonight. And it was short notice, but I'm glad you're here. Please paint the picture for us. What really happened in the last 1 week? I've had Duncan Okat's side. I've had Benji's side. And obviously, everyone has had a different perspective. Everyone in this country is a lawyer, just like it happens during the election presidential petitions. So paint for us the picture from your end as a legal scholar and a dean of exactly what happened in the last week.
Thank you, and thank you for the previous speakers and for the fellow listeners and the host. I think this is a good discourse and a very good opportunity for us to remind ourselves of the Constitution. Maybe to begin with, I don't envy the court. I don't envy the court because they are in a very difficult situation where if you are a typical judge, you feel after these politicians have done their work, of course, guided by law, they put you in a situation where you now have to decide. And you know they don't like you and they don't care for you that much. But now you are the court. And as a court, you must remain within the four corners of the application and assume any prejudice. Now, in my opinion, we say law and order. In fact, the word order and law has become synonymous. That the same law that gave provision of impeachment is the same law that the other side, the deputy president side, is coming to claim their rights has been violated. And therefore, of course, is there a contradiction? Probably not. But they don't rise in a vacuum. Now, one thing, I don't know whether law has changed, but conservatory order do not become
Doctor, are you still here? We lost Daktari, right?
You press and it disappears and you draw again.
Okay.
I don't think that exactly is how the conservatory orders work, like a mega sketcher where you draw your things and you click a button and it wipes it. Because these conservatory orders are issued in context of my right will be a nugatory if you don't stop whatever is going on. So that is the context. I've not got a chance to convince you of my case fully, but it has raised issue as a court. You can see these are a serious issue, but if you don't intervene, this will simply be an academic exercise. So stop things as you give me time to convince you. That, to me, does not become a sketcher where you can go back and say that there was no removal. And go back and say, the lawyers that went for court are very smart. Remember, they didn't bother with the National Assembly. They just went for the Senate because they know this is the last action. So if you say whatever happened in Senate is stopped or should not take effect, and because of that, you have given me you have conserved the status quo. that does not return me back, because if you read the impeachment, once the Senate vote, somebody is impeached. And the reason I differentiate conservatory order from the mega sketcher is that it has no ability to rewind things. It's saying right now, don't move so that this right do not become nugatory. But I also think that ultimately, somebody can say what Ndolo was trying to allude of sharp practice, where, for example, you are in the Senate and you are a senior counsel, and you say, my client, if I don't get my application, the application is give us up to Tuesday, which now they will argue, after all, if you will have listened to us, isn't this back to Tuesday? Fair enough. But that you go to the Senate and say, my application is give us up to Tuesday. Up to there, I have my client instruction. In the case that you don't give me until Tuesday, then the client has withdrawn his instruction. I'm not going to be part of that proceeding. That to me is really who is the client, because a lawyer is an office of the court. A lawyer is the one who is supposed to advise client, and therefore the client cannot peg their case on success. That you'll only proceed to listen in the Senate if your application is granted. Those are very bad things that is happening from very senior lawyers, because then it.
Daktari dropped once more. Daktari, I think he dropped. I think where we are not agreeing, and thank you very much, Moses Kuria, from the President's Advisory Council. Thank you so much. You said you'd join. I've sent you an invite so that you can tell us why you told us there'll be a swearing in and there wasn't. So as soon as you get the mic, we'd like to speak. We'd like you to tell us exactly what's happening. And perhaps because you also sit with the president has been silent for the last few weeks. Perhaps you'll also tell us what is telling you away from this. But I think Dr. Duncan Ojwang dropped once more, and I'll give an opportunity to Duncan, because Dan, I think what has come out of this conversation is the fact that there is different interpretation of the word conservatory. What is conserved and what is not conserved, or what is reserved. Perhaps, why is it that there are so many varying explanations about the conservatory order, Okach, before I talk to Benji?
Thank you so much, Ken. You see, this is, I think, plain English. And if there was any doubt of the meaning of the word conserve, I will read the orders that were issued in Nairobi. And it says, order number 3, that in the meantime, due to the issues raised in the petition and application and the urgency demonstrated, a conservatory order is hereby issued staying the implementation of the resolution by the Senate upholding the impeachment charges against the petitioner. I will first stop there before I proceed. At this point, the court is staying the implementation of the resolution by the Senate. What is the resolution by the Senate? It is the impeachment and removal of the deputy president. So the word that has been indicated here is staying, so that you do not have just the term conservatory order. The court has even gone further to avoid this confusion of English and further clarified and said staying, added that English doing word, staying the implementation of the resolution. So staying means you should not proceed from there. Then after the comma, it says of the resolution by the Senate upholding the impeachment charges against the petitioner. It says the Deputy President of Kenya, including appointment of his replacement. It also goes further and says not only are we stopping, but we're even saying don't proceed with any process of appointment. So that any person reading this, let me tell you, and that's why you'll see proponents of this will start going and starting to say that Paul Muite and the rest, Paul Muite, whom I'm sure senior counsel is not in this platform, so we shouldn't attack them. Maybe it was a game. You know, someone going towards interpretation or trying to understand the orders of court cannot be mixed with our feelings of what happened at the Senate, whether they were right to proceed, whether the deputy president was sick. It is not proper to mix. Those are two different issues. So at this point, we are talking about one issue. Let's not mix, because we will talk about the probity of what happened in a different forum. But for now, the agenda here is to understand the impact of the court orders vis-a-vis the processes that had happened. And it is very clear from the wordings of two court orders that conservatory means it is returning us back to before. And if there was there was doubt today, and I'm happy you've invited Moses Kuri and many other government officers must be in this platform, including Dr. Juang, who also works closely with government. The biggest question you should ask them, if it is as simple as Benji Dolo says, it has no effect, why then haven't they proceeded to swear in a professor today? The simple reason is that they understand and they've been advised. Don't make fools of yourselves. You'd rather go back to court, let the court set aside this order and you proceed. Failure to that, Rigathi Gachagua remains the deputy president, and there should be no doubt about that. In fact, the actions that have happened today of trying to send his officers on forced leave are null and void, because they're anchored. If you read the document, they're anchored on the fact that Rigathi Gachagua was impeached, which has already been stayed by the courts. So they're actually making it worse. And that is why I believe someone somewhere has reasoned properly, has told the government, wait a minute, this is the impact of this decision. But you know, the governments and even opposition must give their people hope. So in this confusion that is temporarily created, they are giving their people hope. But the reality of the day, when we talk about the legal position, it is so clear that this confusion is something that any lawyers are wondering, what is it? We might not agree with what happened in the Senate. We might agree with what happened in the Senate. But one thing that all lawyers must come up and must agree with is the effect of the court orders. That one, there should be no doubt about it. We might say going forward, courts should not, we might give our view that courts should not interfere, or courts should not give orders at such a point where things have started taking place, because you'll take us back. That is a discussion we can have, but we cannot have it within the context of understanding a court order which has been issued. Because if you don't like a court order, you do what the government has done today. I repeat, you go file an application to set aside those orders and convince that court. And we have a position where we always say, even if a court order is written on a tissue paper and it is served upon you, obey it first. Go and question later, but after you have obeyed. Because if you do not obey, let me tell you, it is as simple as tomorrow saying there is a presidential petition, the courts find that uphold the elections of one person, like it did for William Ruto and Rigathi Gachagua, but the sitting president decides, I will not obey that court order. That is anarchy. And that's why I'm saying, if one of the grounds of impeaching Rigathi Gachagua was lack of respect of the courts and attacking the courts, what are we doing, especially by Moses Kuria trying to go and say that if that was attributed to him, I'm not certain about the truthfulness of that. But if he actually went when there's a court order to say we will still proceed, that then means that you are in the same basket like Rigathi Gachagua. Then if that is an impeachable issue, which was one of the reasons that Rigathi Gachagua was impeached, then any state officer saying that we can proceed, and someone was saying that court orders should be put in a basket. Let me tell you, today, if Kithure Kindiki was to have taken oath, he look at the two oaths described by the Constitution, is that I will uphold the Constitution and there is one for office. You cannot swear to uphold the Constitution when the ground you are standing on is an unconstitutional ground.
But
when
Dan,
you are actually...
Dan, do we agree that it's a blow to the government? Because essentially you're talking about what the government has done. They have obeyed that law. that instruction from the court, that ruling. They were asking the court to allow them proceed with the swearing in. The court refused and sent this to a hearing on Tuesday. Don't you think they have complied?
They are actually in compliance. There is no disobedience at this point, and that is a very good thing for the government. Actually, if they had not complied, the first order of business on Tuesday or on Thursday would have been a contempt application instead of even dealing with trying to do away with the orders. But government has complied, which is a very commendable thing, in my view. And they can as well, they have a golden chance to persuade the court with all the arguments that are there as to why it is important to proceed. And the courts can listen to them, but the courts can also decide, no, let us hear the matters or the applications to their end. So it is a decision that will be made by court. But the question is, what is the status obtaining at this point? The status obtaining is that the deputy president remains in office as a deputy president. But upon the courts making a decision, they can go. As I finish on this point, I've asked you, if conservatory orders does not oust the decision and the Gazette notice by the Senate, then what is Kawera Mwangaza doing in office? Have you had any of these government people going and saying there's an illegality? They just disbursed billions this week to all counties, including Meru County. And Kawera Mwangaza at the helm is actually utilizing as a governor. Why is it that we want to have two double standards? We want to have double standards when it comes to the deputy president and when it comes to the same law that applies to a governor who has been impeached? It cannot be. And that's why I'm saying this is not rocket science. Conservatory orders have been issued from the days of Wambora. It has come all the way. Twice it has come to Peter Bunya. It has come to even Gashagwa's brother, who was also impeached, went through these impeachment processes. It is not a new issue. Conservatory orders are issued. Actually, it is the norm in our constitutional dispensation. Conservatory orders was given birth by this constitution. Before, we didn't have anything known as conservatory orders. So it came to actually cure that, and it is what is governing the status quo now.
All right. Thank you very much, Duncan. You've taken a lot of time, but at least you've explained, and I've sent a number of invites to quite a number of speakers. I'm waiting for you to accept the invite. Yes, but I'd like to bring in Benji. Benji, I know you've been itching to say something on this.
Mine is very short because we're going to open up the platform for other people to speak. I've been laboring a lot about jurisprudence and about the political culture in this country and the culture in the judiciary. I'm happy to hear Wakili confess that conservatory orders culture was not there before, because I've always, in fact, I was going to suggest that we introduce a subtopic called misuse of conservatory orders. Misuse of conservatory orders. Because to me, Ken, the way I see it, it's like the court many times does not really apply itself to the length and how, I hope you can hear me, how does a court rush?
Yes, we can.
How does a court rush to injunct a process that is so delicate as to determine the deputy president of the Republic of Kenya? How do you rush on something like that? And why I use the word rush is because, again, back to the Constitution, my favorite document, Ken, Article 149, and I hope you have the copy of the Constitution yourself. Article 149, vacancy in the office of Deputy President. Article 149.1, within 14 days after a vacancy in the office, if in the office of Deputy President arises, the President shall, that's within 14 days, nominate a person to fill the vacancy. And the National Assembly shall vote on the nomination within 60 days after receiving it. Why I wanted to read this article, Ken, is because as a governance analyst, you see, for me, I don't confine myself to law or to the Constitution or to, legislation. I'm trying to see and define on this space the powers of the president. To define the presidency or the president, only one person, yes, it is checked by different processes that have to be done, can nominate. So the way I see it is a lot of these interruptions that you see, it's just a furtherance of the war within the presidency, which is very unfortunate. It's an attack on the president. Okay, it's an attack on his agenda, and that's why I raised the question at the beginning of this space, Ken, and I've raised it severally on social media and elsewhere. If you have a working relationship that has broken down, if you have a working relationship that is irretrievable, if you have serious issues, within the presidency, there's serious issues such as national security, because the president sits, of course, chairs the National Security Council, um, deputized by his, deputy at the council. I'm not really sure, but I remember in the days when I worked in the presidency, we had something called NSAC, the National Security Advisory Council, and that is just one aspect of it. There's operational stuff. You saw the deputy president complaining that he had been kicked out of the State House Communications group by somebody called Mayo. I am just quoting him. So there's operational, reach. In fact, and I don't want to divulge too much here, but it is to my knowledge that sometimes in the function of presidential escort, um, um, cars are swapped. Sometimes the cars that the president uses are also used by the deputy president. So why am I saying this, Ken? Because trust, ultimate and utmost trust, is so important within the functioning of the presidency, where you have a deputy speaking in public, contrary to what the president is saying, where the president leading an agenda, but the deputy doesn't think that that agenda is a priority or that is the way to go. How then does a court force itself? Me as a judge, I look at what's happening. I look at the National Assembly. I look at the Senate. I listen to the press conferences by Rigathi Gachagua. How do I inject myself, Ken, and put a conservatory or whatever court order that then forces Gachagua to go back and sit with William Ruto? I think, I'm sorry to say, but I think lawyers need to wise up. I think the court is reckless. I think the court, many Kawira Mwangaza has not even been impeached once. This is twice, thrice. How does a judge force Kawira Mwangaza to sit in Meru County and do her job, which MCA said she wasn't doing? That's why she was being impeached in the first place. There was complete anarchy and dysfunction in the county. And so there's misuse of conservatory orders. It is shocking to me that someone is bold enough to extend this into the presidency. I am trying not to be personal. We need to be also practical. These officers that were suspended today from, by the State House Comptroller or whoever head of government, for this kind of thing, Ken, for all intents and purposes, these would be spies. These are the closest men to Rigathi Gachagua. If you look at revelations, even on how they were hired, on their qualifications, these are the people that he trusts the most. These are people who owe him so much. How do you leave those people? You cannot just have a dysfunctional, system in the name of a government. How do you leave people like those that then will be just channeling out documents? And that's why in countries like the US, for instance, um, mishandling of classified documents is such a serious case, even as pertains to a president. You have seen President Trump get in trouble, including President Biden, for just handling classified documents in a lackadaisical fashion. And this is what would happen if you have senior officials in the deputy president's office that are going to sit there, and then another deputy president comes, and their loyalty is where? To Rigathi Gachagua. And so I'm trying to have this discussion on your space, Ken, from a practicality standpoint. How is this president ever gonna work if it is chaos and crisis year after year, court order after court order. I'm seeing people having the audacity to say that they should have stay orders until 2027. Do you even love this country when such thoughts are in your mind? When you're saying such things on social media, do you even love this country? And then you're going to expect the government to deliver. I'm one of the biggest advocates giving the most pressure to government to deliver, because we voted for this government, we supported this government, and we need them to deliver on affordable housing, to deliver on social healthcare, to deliver on the economy, on creating jobs, on energy prices, okay, on security, even on healthcare. Look at the story on the media today on Mama Lucy Kibaki Hospital. Healthcare is almost collapsing. How is this going to happen when it's just war within government? I hope I've not been too rough on anyone, and I respect everybody. I respect you, Duncan, but you and your cabal of lawyers, I think you guys are completely on the wrong. Thank you.
Benji, thank you so much for your views. I think you've taken us back to, like, umeturudisha nyuma sana. Watu wamesonga mbele. Now there is an impeachment that has happened, and as much as Duncan Okatch maintains that the deputy president is still the deputy president, is the impeached deputy president according to the Senate. There is a stay order. I've seen a lot of reaction online based on sentiments that I've been expressing, but these are my sentiments, and you're free here to express your sentiments. Lydia Ngaira, you've been on hold for a long time. I've given you the mic just to hear what you have to say about our discourse today, and probably weigh in where the country is. And we ask ourselves tonight, the judiciary, the politics of the judiciary that are playing out right now, are they healthy? Are they helpful? There are stay orders. There are people hoping to swear in someone else. There is someone hoping that the court can restore them to their previous position. So, Lydia, you have the floor. Lydia Ngaira? All right. Lydia Ngaira is not ready to speak, and she has been hanging for a long time, so I thought I would give her the mic. But as we think about this, I think we also need to think about, most importantly, the Constitution and what the Constitution says. It says, for example, myself, I hold this, that the only article of the Constitution we should be looking at is Article 149. I don't know why we need to go all length and breadth to justify what the president did. I hold that 149 for me is supreme. And Fwamba NC Fwamba is already here. Wakili, good evening. Good to see you. Perhaps you can also weigh in our topic tonight. Legal or political, the position or the standing of the deputy president tonight.
Is it my time?
Yes, it's your time.
Thank you, Ken. I think we need to be very careful with what we say. We need to know the difference between what we wish and what is real. There are those ones who wish that Gachagua is supposed to be sympathized or empathized with. But the reality is that as we stand today, based on the work of our institutions as defined by our constitution, Parliament did its job, the Senate finalized and made Gachagua an impeached deputy president. So as we speak, from where I stand, I believe the position is that Gachagua is a former deputy president, and that's the appropriate title that he should be having. And Kindiki is supposed to be the incoming deputy president, who is awaiting swearing in based on the decisions of the courts. That is the position that Kenyans need to understand, as opposed to some of the Gachagua sympathizers. I'm told that he has been crying all through. I don't understand why he claims to have been a Mau Mau guy and then he's crying like a baby. So sympathy is very different from reality. And again, even if we were to push that he becomes the deputy president again, under whom is he going to be the deputy president? Is it the interest of an individual that the country is going to be at standstill to pursue, or the country is supposed to pursue national development? It's important that this issue has been moved, and we are now looking forward to focus on national development. And I wish that as Gachagua pursues whatever he considers as his rights through the courts, the country keeps moving on. Because what he's doing right now is trying to play politics with the whole country, trying to seek sympathy and at the same time stagnate all of us because of one individual. There's no time at any given time in this country. Remember what Saito said in the past, that there comes a time when the nation is more important than an individual. We cannot be at a standstill just because of someone who wrote his own political obituary and found himself in a situation where he's helpless. For those ones who are trying to support Gachagua, they should get back to the things that he has been saying when he is so much in positions of comfort. Things have become so different. Now he looks like someone people are supposed to empathize or sympathize with. Unfortunately, and I heard Senator Omogeni say that during the impeachment debate in the Senate, that he's a friend to Gachagua, but based on the facts that had been presented to make that decision to vote for his impeachment, the country needs to move forward, and we are prepared for the incoming Deputy President, Kithure Kindiki. The courts have their right to do what they consider is just, go through the processes, but ultimately they'll have to consider national interest as opposed to an individual's interest. Thank you very much, Ken. That's my 2 cents.
Fomba, where do you draw the line? National interest and individual's interest?
National interest is based on the establishment of our constitutional guidelines. And the Constitution clearly defined the boundaries of our 3 arms of government. I want to identify with so many decisions of the court when Gachagua made a lot of applications before the impeachment, trying to stop a just process that was being done by an independent institution. Because courts consistently ruled that they cannot interfere with the working of other institutions in government unless if there comes a time when he thinks that his rights have been violated. But how can you claim that your rights have been violated when the whole country, in a democratic process, by 80% has by consensus said that you do not qualify or you are not suitable for that position? Impeachment clause was not put in our constitution by accident. It was put there because they knew that political accidents, the type of Gachagua, will easily happen. And when a political accident happens at the expense of the country has an opportunity to correct. And that impeachment process is one of the opportunities provided by the Constitution to correct a mistake that has happened. And I think Rigathi was a mistake right from the beginning. While the president might have considered him as a friend and maybe an ally of sorts, he never knew that this is someone who was so full of himself, narcissistic, someone who thinks that is more important than anybody else, someone who is so ambitious to an extent that his pursuit for power was more important than the interest of the country. Therefore, that kind of characterization of Gachagua is what has led to him to where he is today. Remember, even his own member of parliament voted against him. Even his narrative, his divisive narrative of Mount Kenya does not hold water, because if your own people at the backyard are the ones who are voting against you and you're claiming to be leading them, then it does not even make sense. But that's neither here nor there. You knew that there was some consistency in terms of the voting. You saw on the floor of the National Assembly, Millie Odhiambo, reading the public participation report, it stated that 65% of Kenyans were against Gachagua. They wanted his removal. Then when we go to the floor of parliament, 282 members of parliament, out of 349, of course, 4 seats are vacant. So out of 345 voted for Gachagua's exit. That is 80%. When we go to the Senate, the most contentious issue, which was the issue of shareholding and going against Article 10 in terms of inclusivity, the Senate voted overwhelmingly. 53 senators out of 67 voted against him. That is again 80%. There's a consistent pattern that this guy is not suitable to be holding that position. But now, in the name of him loving himself so much at the expense of the country, is busy running around with these interventions, knowing very well that he has no chance of winning anything because consistently he has lost. What miracle does he expect that is going to happen that he wins out of nowhere? And again, even if he were to be reinstated, how is he going to be a deputy to someone who is not able to work with him anymore? Are we going to experience a lot of noise and squabbles all the time at the expense of national development and progress? That is not the right thing to do. So I think the courts, as they make decisions, they also look at national interest, like I've defined it, in a wide manner or in a wider scope, as opposed to a myopic scope being peddled by the former deputy president. And I want people to understand that it's important to keep on reminding him that he's the former deputy president so that it also sinks in him so that he does not continue mourning for too long. How many times has Raila lost elections? And he has not been whining like a baby the way Gachagua is behaving.
You know,
he is supposed to move on. He must accept and move on now. Thank you, Ken.
When we began this conversation, we said that as much as we may not like Gachagua, as much as we love this country, we should a little bit be respectful with what we say, but you're entitled to what you're saying, but we should at least be respectful. Whining like a baby, I don't think is respectful for a former deputy president who was removed by impeachment. Duncan, I know you want to weigh in. You've been listening for the last 1 hour. Pardon? Someone saying something? Okay. So, Duncan, I want to come to you because you've had different interpretation of what happened. I'm coming back to you. But there's an argument that has been going on online, on X. And this is an argument between a teacher and a student. I'd like to read some of the excerpts. Now, this is our teacher, Duncan Okach. This is our teacher. So this is Senator Ojenda and Willis Otieno, who yesterday, by the way, and I really love to see Max Miawa if he's on Twitter, because yesterday he had very good perspective. Actually, based on their conversation last night, I decided to host this Twitter space. And thank you everyone who's come on board. There's so many people here who are trusting us to hear what exactly is happening. So I'd like to read a few of these if you've not seen them. So Professor Ojenda tweeted, the political question doctrine contemplates no judicial recourse for presidential, in bracket, deputy presidential impeachment or impeachment. The decision of Parliament, in bracket, National Assembly and the Senate, is final and is directing us to Article 144 of the Constitution, which I believe is on the removal of the president on grounds of incapacitation, which was not on trial before the National Assembly and the Senate. So, as a response to this, Willie says, while the political question doctrine may prevent courts from adjudicating the final outcome of presidential or deputy presidential impeachment, this does not mean that the courts are entirely excluded from the process. Now, his reasoning is this about the doctrine of political question. The doctrine of separation of powers recognizes that Parliament has the authority to impeach, but doesn't mean president's actions are beyond constitutional review. If the process is flawed, or if it violates constitutional provisions, the courts have the right to intervene. That was Duncan Okach's point right at the beginning, that the courts have the final say in any decision, even executive decisions. So further, Willie says, where was I? Let me read it again. If the process is flawed, or it violates the constitutional provisions, the courts have the right to intervene, not to decide the fate of the presidency, but to ensure the process adheres to the law. And finally, Professor Ojenda responds and says, Parliament sits as the representatives of the people. The people. There can be no flaw in their final decision. 285 members of Parliament have spoken. 53 senators in aggregate, I think, spoke. Where is the doubt? So Willis' response, the idea that there can be no flaw in their final decision is misguided, especially when considering constitutional democracy and the rule of law. Majority does not equal legitimacy. Checks and balances are essential. The Constitution is supreme, and all organs of the government, including Parliament, are bound by it. Article 1 of the Constitution vests all sovereign power in the people, which is exercised through Parliament, the judiciary, and the executive. This means Parliament is also accountable to the constitutional framework within which it operates. And the conversation goes on and on and on to a point that Willis is laughing. So I think here one thing that came out was the separation of the powers, and secondly was the fact that we have donated our power to our elected representatives and they spoke. And this is the reason why I personally, I insist on Article 149 in whole. So I don't know what you think, Duncan, as you respond. Then I can open the mic to Victoria, Nyuka Bell. Victor, you'll be speaking next, but let me hear a rebuttal from Duncan Okach. Okach, take the floor.
Thank you so much, Ken. I think it's just in the interest of balancing, because there are speakers who have been pro the impeachment, and it's good to balance, and especially so that we have a broader perspective of this. Now, it doesn't matter, and I like the words you use, doesn't matter how bad Gachagua was, and I'm not saying he was very good in his utterances. It doesn't matter how ugly some people might think he is, or how bad his voice is, or how tribal he is. But from the perspective of the law, the only thing that must happen is that fair process is something, and fairness is something that must be accorded even to Lucifer himself if he was to be arrested in Kenya one day. And that is nothing short of what is required by the Constitution. So we can use so many words. We can say how bad he was, but that is not a justification of now going against what our Constitution provides in terms of procedural justice, and now say that we are using it to punish you. Injustice to one person today can be injustice to all of us tomorrow. And that is simply what we lawyers are saying. Let's not just be so happy because today it is Gachagua. Tomorrow it will be you, tomorrow it will be your father, the other day it will be your uncle, your mother. It can be anyone. So what should stand firm is the rule of law. And when we look at the rule of law, and something that Fuamba has not mentioned, and intentionally I believe so, he has not told you what is his position in respect to the court orders. What is the import of the court orders today? So that if his position is that the court orders means Gachagua remains in office, it means status quo ante, it means conserving, then it doesn't matter how bad we feel. It doesn't matter how we think he will not work with President Ruto. That is not our issue. Our issue is that we are constitutional democracy. We have to obey that. Let's deal with those things. In any case, if someone says, how will he work with President Ruto? Are you a visitor to Jerusalem? We had the last 5 years before 2022, where a whole 5 years, the current president did not work in harmony with his president then. Did the country stop? Look at the constitutional architecture and framework, whereby what is the role of the deputy president? Has the deputy president been given the handbrake of the country, where he can always pull the handbrake and we come to a halt? The deputy president, I can tell you, is so ceremonious that, is the same like deputy governors. If you ask people who is a deputy governor of Kiambu, they will not tell you, unless maybe you come from Kiambu. If you ask someone who's the deputy governor of Narok, they will not tell you, or even of Homa Bay, where I come from. They will not tell, some of them will not tell you unless you've interacted. So that tells you a lot in terms, even Mombasa, you will not know, because they are ceremonious. They don't have a handbrake for the country. So it is a fallacy to say that just because these people they are not friends, that the country will actually grind to a halt. It is like a marriage. So many families here in this country, I can speak for Kenya. Many people go in as, you see, who ni Baba Nani, this other one is Mama Nani. And they feign that they are a functional family, but no. When they go inside there, people sleep on different corners of the bed, or they sleep in different even rooms. But it does not, the aspect of raising children continues. So it is a fallacy to say that just because they do not seem to agree that it means that now let's violate the constitutional procedures under Article 145. Ken, that is so wrong when you say that we shut our eyes to the actual article that speaks to impeachment and you just jump to the aspect of vacancy. There is something that gives rise to that vacancy, and that is Article 145. If the procedure, and the law is like this, and it is important I say it, even if you find someone red-handed, his hand in the cookie jar, and you even take a picture, but you don't give that person due process, let me tell you, it's all for naught. The court, and you fire that employee, the court will still find that you fired that employee unfairly, irregularly and unfairly, and unlawful. And it doesn't matter that you have evidence, the hand even in the hand. It doesn't matter. And that is what we are saying. We are not saying he's the best of the deputy presidents, but we are saying tomorrow we do not want this injustice meted out on someone else because we set a bad precedent. Let us do the right thing, do it correctly, do it procedurally as per the Constitution. And if the courts have said, wait, let me hear the voice that will tell us, let's disobey the court so that we look at this person as a former, because you are now calling him a former DP. You're already in contempt of court yourself, even Ken. You cannot be referring to someone as a former DP when we have told you the law is very clear that everything has been halted.
He was impeached. Did the Senate impeach him?
The Senate impeached him, but the courts have reversed and said we are freezing that impeachment and the effect of the impeachment.
Has the Senate reinstated him?
The Senate,
or
let me tell you,
or state the decision of the implementation of that resolution. Have the courts removed the impeachment tag? Have the courts reversed the votes that were taken in the Senate, Duncan?
Let me tell you, and Ken, you are a lawyer. The Senate has no role in terms of reinstating, and it will never reinstate anyone.
No, the judiciary.
It is the court. It is the court that will make a determination of reinstatement and quashing all what happened in the Senate.
As
of now, the courts have said we are any effect. They have not reinstated. They've said any effect of that impeachment has been frozen. Any resolution and implementation has been frozen until further notice. To the extent that as we stand here, he will only stand impeached once the court have made that determination, or if the court varies these orders. It is as simple as that. If the court varies the orders,
Wakili, but you agree with me, even as at now, the courts have not reversed the impeachment. The only thing the court has said, stop the implementation of that resolution, stop the appointment of a deputy president, stop the swearing in of Professor Kithure Kindiki. That is what the court has done. But it has happened. One, the Senate have deliberated. Two, the deputy president has been appointed and confirmed by the National Assembly. And three, the only thing the court has said, no, don't swear him in, wait until the deliberations are on. Then they went, are concluded. Then this side of Kithure Kindiki went to the courts and told the courts, no, allow us to swear in Kithure Kindiki. You can't imagine what can happen in this country if the president, anything would happen to the president right now. Allow us to swear him in. Then the court said, no, we will not allow you. Let's listen to both sides before we can allow you. But even you agree with me that that act of the Senate has not been reversed yet. So when I say the impeached deputy president, the former, because when you are impeached, you become the former. I am not out of context.
Ken, you know, in another context, I would have explained this to you in Luo. And I think, and I think in terms of these orders, I think it's important now that we translate them in many languages, because I agree with you. He's impeached as we speak. That has not been reversed. But the court has said that, before the court, the effect of impeachment is removal from office. That is the effect. The court has stopped the effect. You are impeached. But the court has said staying implementation of the resolution. One of the byproducts of this is removal from office. The court has stopped removal from office. Then how can you come and tell us he's not in office? When the court has already said in no uncertain terms, I'm stopping any implementation thereof. And removal from office starts from gazettement, going forward until even IBC itself declares the vacancy. So gazettement itself as a subsequent document has already been stayed.
Okay.
How do you then argue that this person has been removed and becomes former when the order is very clear that it has stopped everything, including what you are actually talking about?
Except the reversal. Duncan, I hear you. I'd like to read 2 tweets here before I go to Victor, then Joshua Malidzo Nyaya. So I'd like to read what Honorable Peter Kaluma tweeted. He said, Kenya's new Deputy President Kithure Kindiki should be sworn into office immediately, not later than tomorrow, which is today. Those, including our good judges who think this is an ordinary matter, should imagine what would happen to Kenya were anything to happen to the president, causing him to be absent right now. Mugambi Nandi on Twitter says the speaker is misleading. And this tweet was done when Duncan was speaking, Duncan Okatch. So he said, in effect, Duncan Okatch is misleading with confidence. Conservatory orders do not reverse actions already taken. Per the Constitution, removal took effect the moment the Senate Speaker announced the result of the vote. I know we've talked about this, Okatch, and you'll get an opportunity to speak again. But let me now open the mic to Victor Oria, and let's hear what you have to say, Victor, before we let Joshua Malidzo speak.
Yeah. Hi, Ken. I'm Victor from Nyakach, and I'm not a lawyer, so I'm not going to get into the legal jargon. But ever since I became of age, I've realized that a lot of lawyers who pretend to be scholars, and pardon my language, I call them lawyers of convenience. Depending on the side they are standing on, they will interpret the law differently. That's why we are where we are here. And I also hear those arguments by Peter Kaluma and the likes of Makau Mutua. Makau Mutua, even Samir, when was it Azimio was in court in 2022, he said some things about, court orders are not like, things to be joked with. And now you can see him rubbishing them because now the shoe is on the other side. And this argument that what would happen if the president is not there, where is the president going? And if the president is not there and the DP is not there, see, the law is clear on who takes over. So why are we rushing this process if we know what we are doing is right? What's the hurry? Where are we going to? If you've impeached Gachagua and you are sure that you impeached him on true grounds, I personally, I have no liking for the man because of his politics. But that being the case, he still needs to be accorded legal representation and legal hearing to justify himself. Kawira is in office because of a court order. Martin Wambora finished a term of governorship because of court order that started from the High Court to the Court of Appeal to the Supreme Court. So why are we now thinking like, and if the DP is inconsequential, like we keep saying, everybody keeps saying that office is inconsequential, then what's the rush of trying to approve Kindiki and swear him in to take that office if it's an inconsequential office anyway? So I think we are just playing politics. We are playing politics, and I like it because we are stretching the limits of our constitution and we are trying to see where we can get. But we should stop pretending that, swearing in Kindiki is probably going to be like, increase the butter on our tables or whatever. No, it's just siasa. Ni siasa tu tunacheza hapa kule, and we can try to sound as clever as we want. But the real thing is we know the deputy president has no powers in this country. And the only reason why even probably Gachagua has been impeached is because he was trying to create a constituency. We know that, and if I go back to history a bit, why did Raila Odinga and William Ruto clash in post-2007? Because during that period, most members of parliament in the Rift Valley belonged to the ODM party. Now ODM ni chama ya baba. And Ruto was trying to flex his muscles to create his own political constituency. They said he was selling maize in South Sudan and whatever. He was impeached, Kibaki akamrudisha. So that's what Rigathi Gachagua was trying to do. And the president has just been clever enough to see it earlier. And he has not said anything about it, which I really find to be very good. I mean, Nyamaza kabisa, he doesn't want to be implicated in anything because he didn't know how this thing would go. But that being the case, I don't think Rigathi Gachagua, if I were him, I would just want to be clear to say that impeachment was wrong, and then just resign and then go back and see if you can carve your own political path. Because he knows that if this thing stays this way, it's 10 years out of office, and 10 years is such a long time, you become irrelevant. So I think for me, that's how I'm seeing this whole thing. It's not the rush within it's been conducted. The rush within which it's been conducted points to something very sinister. It's not been done in good faith, in my opinion. If the man is sick, if the man is sick, of course you don't want him. You already say you don't want him. Give him that time. Tuesday. Okay, Tuesday come, we grill you, and then we vote. What's the rush for? So anyway, I'm not a lawyer, so lawyers will give all manner of reasons why, this thing has to happen within this time period and whatever. But come on, we live in Kenya. There was even a time where it's not even far away. It's just the last parliament or the last government that we had when Ruto went rogue for 3 years. So technically, we never had a DP. Matiang'i was acting as a DP. When he did the country suddenly fly to Pluto? No, we are still here. So let's be fair to Gachagua. We may not like him. We may dislike his politics, his rhetoric, his language. We may have so many negativity towards him. But the one thing that we should never lose sight of is the rule of law. There's a reason why we are a country governed by the rule of law. Because if we lose the rule of law, then we become a jungle. Because what's going to happen next is everybody is going to start rubbishing court orders. So you sell me a piece of land, somebody goes and gets a court injunction, and I say no, I don't follow that. And if many of us start doing that, where do we end up? So give the guy his time in court, let him present his case. If you have, I see you had members of parliament and senators. You can also have judges. They can rule for you or against you, and then we see where we go. But this thing about, it will create a constitutional crisis or whatever, all that is nonsense. Because in this country, the president still holds too much power, despite the fact that when we made the new constitution, we gave parliament power for oversight. Our parliament is still hallucinating from the Nyayo era, and they still think like they hold allegiance to the president. And there's no problem with holding allegiance to the president because he's the leader of the nation. But that should not stop you from thinking independently and standing on your feet. I mean, even look at how the senators voted. I like how Crystal Asige spoke on the floor of parliament and voted. Cheragay spoke so well about, these things are, blah, 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 and then he voted for the impeachment. So you see, that's where we have a political crisis in terms of values. It's a value crisis. It's not even the fact that we don't have good leaders. It's just a value crisis. And if we can sort that out, and value means respecting each other, respecting what the courts say, even though you disagree with them, respect what the courts say. Tuesday will be here. And if the courts say we are going to sort this out we know it's a constitutional matter, we need to sort it, they'll say, okay, we'll sort this within 2 weeks, within 3 weeks. So we all wait for that 3-judge bench or 7-judge bench or whatever Koome will create to sort out that matter. It's good for Kenya, it's good for our constitutionalism and for our jurisprudence, and that's how we grow as a country. But if we start disobeying court orders, we are creating a banana republic. And we should not be surprised. We should not be surprised because we've seen all those things lingering on Twitter. That come 2027 or 2032, the president decides that we are not going to have an election. And then what are we going to do? Are we going to run to the same courts that we've been disobeying? So even as we discuss here, wale wako na interest kwa hii matter, those who are pro-Kindiki or whatever, remember the rule of law is what stops us from being a South Sudan or a Sudan or those Western African states that are in turmoil right now. Wacha nifungie hapo Ken.
Asante sana, Victor. Asante, thank you. We are Kenya. Kenya is our business. Joshua Malidzo, I'm going to give you an opportunity, but I see Dr. Juang is back and another name. So, Daktari, I'll talk to you. And then once you speak, you can drop off so that I get an opportunity to give as many people as possible an opportunity to contribute. I'd just like to have Dantan and perhaps Benji still maintained. But Joshua Malidzo, you can go on. Then Mohammed Mahat. Then we open for Dr. Juang, anajita hapa Arizona. So Joshua, please proceed. Joshua? Someone's mic is live, but it's not Joshua. Okay, let's cross that. And Mahat, Mohammed, if you're here. Mahat. Okay, Mahat is not also speaking. So let's go to Dr. Ojuang. You've been listening to the contributions on the floor. Perhaps you can now come back and weigh in now that you've had more than one perspective.
Indeed. Am I audible?
Very audible, sir.
Thank you, Ken, and very good discourse and real good discussion. I support a lot of emotions that have been displayed. Maybe in summary, so that other colleagues can also weigh in on this. There's the difference between rule of law and rule by law, and I think one, for example, when you look Thursday, the application by the former deputy president who fell sick through his lawyers, that you know what, the deputy president is sick. Please let us wait until Tuesday so that he can be heard. When that application was rejected, then his lawyers say, now we have no instruction from our client to continue. You know, court usually look at the totality of events. Surely, there is no client who should instruct you that you only stay in court when you are winning. When any of our application is accepted, is the condition for you to continue with the proceeding. If you do any application and it is denied, you take the leave and you lose the instruction. And that, I think, at the overall, as I start the discussion also, is back to what is the role of a lawyer. A lawyer is an office of the court. An advocate is an office of the court. An advocate functioned to the court, and that Senate was a court by law. They are not judges, they are not whatever, but by law, they were quasi-judicial. You do not walk away and say that unless you hear my application and do as I want, I'm walking away. And therefore, you can follow the series of events and you can simply see a client who is not very sympathetic to court, because law is a social science. And judges are also human beings and they look at context. You can see a team that will rather prosecute the issue in the court than use the arm of the government, which is parliament, that is given this power. Publicly from the press, the action inside, walking away, falling sick on the court, but that is in a light notion because we can all fall sick, falling sick on the Senate and all that. But on substantial issue, you know, I think we are caught up into paralysis, and sometimes part of it is our making. What is so much different between if Deputy President Kindiki, the appointed nominee, was sworn in yesterday or Wednesday or Thursday? And that is why sometimes, you know, one might win a battle but lose the war. And secondly, that we might be so much looking at the side issue and not the main issue. And that is why, to me, I'm more interested in what do you think the former deputy president team is trying to achieve in court realistically. Give their case the best benefit of doubt. Give their case, move it to the high heaven and give it all the goodwill. What do you think they're trying to achieve? And what remedy can court give at this point? It is my submission that I believe they are good lawyers. Even in the Senate, they were building a record for the court. And you could tell that they knew that maybe the Senate, we might not have numbers, but we are building a record for the court. And that record was built very well from what even senior Professor Ngoya was doing and all that. And it is for what? I don't think they expect that court can go back and undo the impeachment. Remember, the title of the article is removal by impeachment. And therefore, they are not, the parliamentarians are not doing something officious intermeddler or shooting from the hip. The Constitution gives them that power, that there is 3 ways somebody can leave office: after death or after termination of the terms. But there is another way where you can be removed. That aspect of removal is both for political and legal solution. Let us not divide so sharp the line between law and politics, because we are being mischievous. When I say politics, I don't mean holding microphone and standing in the podium. Deputy president is a political appointee or elected. The president is a political appointee, and that is why court in it, the framers in their wisdom, both by design and by putting the right institution, said that these people are better judged by fellow politicians and fellow elected leaders. They will have easily come with ISPAC or LSK or a professional body, but they knew, being that they are elected leaders and being that they are politicians, their fate and their accountability is better done through parliament. So that 99% of the modern democratic constitution and constitutional democracy envision removal. That the absolute sovereignty or popular sovereignty, which is through voting, can be tampered with if anything happened in the course of that journey, and people don't wait. So what do? For a member of parliament, you can recall him. For a CS, you can not impeach, but a vote of no confidence. For the president and for the deputy, this is what happened. So in that context, then, as I conclude, in that context, then you can see, if it could have happened to the president, that he was the one who is impeached, automatically the deputy becomes the president, he appoints. It's a seamless process that the law thought through it. So this idea of things seem rushed, do you know the court even give that the National Assembly should report to the Senate within 2 days? Why? Because our constitution was so prescriptive, knowing we are dealing with the Wakora system where somebody might sit. How does it affect President Ruto so much if he does not have a deputy? You know, there's a time Moi went on for almost a year without a deputy. Some of the president might like it, but the constitution above vacuum, and they understand that as they reduce the power of the president, they put some in the deputy president, and it is part of check and balance, so that you are not going to work at the whims of the president, but parliament can impeach you. Therefore, I still consider that the remedy that the former deputy president really is seeking in court is to make, he did very well trying to make that process look like there was some issue that were not taken care of, like his request when he fell sick for the process. Therefore, he will try to persuade court that I know you cannot make me a deputy president. The court cannot, because I see all the legal minds are also agreeing that at best the court can only look at the process and not the substantive. What is the substantive? Was it bad enough for you to remove him? No court can get to that. Court can only look at the process and smell whether there is something fishy. Now, what remedies due? The court can say, you know what, let us split the baby. At worst, you get your maybe a year's salary. Then you also are able to run. I see a situation where, because he's time barred in resigning, he wants an assurance from court, unlike Sonko, whom court said you cannot run, for court to tell him the only remedy, because we see that some of your rights were not granted, therefore you can run immediately. And I think that will be the price or a remedy that the court will give. Finally, final submission is that when you look at the conservatory orders, and I've had a lot of argument, it cannot become a mega catcher.
We lost you. Dr. John, we lost you. Okay, as we try.
It was given in the context that the conservatory orders was given in the context that judges, if you don't give the conservatory orders, then what we are doing here will be academic exercise. Kindiki would have presumed the office. So the court did not say, we have said you are not impeached. Court is simply saying, let the process not move. Let us conserve. Let us have status quo. They did not quash the Gazette notice. They did not annul anything. They simply say, let the process not move. In fact, Justice Muita was so technical that he simply said that the process of replacement, which everyone at the four corners in good faith will say, but Justice Muita, by the time you were giving this thing in noon, Kindiki had already been gazetted. But then there is the Kerugoya one, which now went further to talk of the process and even name Kindiki. Now we are in a situation where Kindiki cannot complete the journey because there is a court order. But meanwhile, the Deputy President, former Gachagua, is impeached and stand impeached. Now we are in that limbo. I see a situation where a court might say, you know what, we can give you this final ruling within 2 days. But as Okach was saying, that in a case where even an employee is unfairly terminated, courts usually do not take you back to your work. Courts usually say, you know what, you need benefit because you cannot have forced servitude and you cannot force somebody to be deputy president, especially when the arm that was given power to impeach him have done. Usually when court deal with somebody who is exercising their constitutional mandate and the executive and parliament have converged on an issue, court are very hesitant to rewind, and at best, law is order. And law and order demands that they will say, we can hear you, but there's no way we can put you back to being a president as a politician, that position is of trust and you have lost the public trust. So that what is due to him, these public officers are not like right to liberty. You are not going to jail. You are not losing a property. It's a trust. And within that trust, therefore, what is due to you
Dr. Juang, we lost you again, but there are other callers. So Joshua, I don't know if you're here. Joshua is not here. Bernard Mzalendo?
Yes. Thank you.
Proceed, Bernard.
Good evening. I hope I'm audible enough.
Yes, you are audible enough.
Okay, thank you so much. Now, I think I also just want to make some submission on the topic going on. First, we need to understand that the process of removal of the deputy president was a political process. And the legal beat or the judicial process starts from the point whereby now maybe the deputy president has gone to court and therefore is looking for legal redress. But entirely, it is a political process which was conducted right from the National Assembly, then up to the Senate. Now, for political processes, not all political processes can be solved using a legal process at the court. Some of them will actually look for political solutions, whereby if it were possible, then probably the deputy president, the outgoing deputy president, would have maybe some sitting with the with the sitting president. Then they find out a way through it they can solve the same process. Now, my point is this, that up to where we have reached, I don't have a deep understanding of law, but I know that up to where we have reached, Deputy President Rigathi Gachagua stand impeached. And if you look at the ruling that was done by Chacha Mwita on the interest of separation of powers, it is very clear. And I think that one will also be referred by some of the senior counsel when the court will now be making pronouncement. It is very clear that the judiciary, being an arm of the government, the same way the legislature is, and the executive, they cannot interfere with the process that the legislature has undertaken, such that anybody who might be thinking that Rigathi Gachagua can still be reinstated in the office, it is not possible. Because just as Dr. Ojwang has just said, when you are terminated at a workplace, you cannot be, it is very difficult for you to be reinstated because the employer just terminated you. They don't want your services. The only thing that can be done is maybe to compensate you, depending on what the court process will come up with, whether you are terminated legally or not legally. Then, secondly, if you look at the point where the Senate decided to proceed with the impeachment process, after the Senate had some voting in the House, and the senior counsel, the counsel for DP Rigathi Gachagua decided to seek leave, you realize that the other supporters of Gachagua in the House, in the Senate, participated in the event. They participated and they voted. Some of them voted no, others abstained. So it means that up to that point, they kind of legitimized the whole process of the Senate. And so it means that even though Gachagua is in court looking for the legal redress in terms of maybe was not given enough time to be heard in the court, in the Senate, but his supporters who are also in the Senate, because obviously he also must have had some of his supporters, the ones who said no. They legitimized the process and they agreed and they accepted to participate in the same process. Of the best would have been if maybe they also walked out of the Senate, so that they say now that the DP is being impeached outside the constitutional purview, then we are not going to take part. At least up to that point, they would have something to say that the process is not legitimate. But as it stands now, it was legitimized, and therefore the only thing that maybe the DP is looking for is that the court to say that the process, even though he has been impeached, but maybe the Senate or the National Assembly or whichever, or maybe the executive did not follow the due process, and therefore he can still be allowed to run for office. I think that is basically what is looking for. Because even himself, he also understands the implication, the political implication of his impeachment. He understands that under no circumstance is he going to come back to work as a deputy president? First of all, his office, the over 108 staff have been sent on compulsory leave, meaning the office, the functionality of the office is being paralyzed, has been paralyzed by his impeachment. And therefore, a new person is just about to occupy the office. So I think we need to really understand, and lawyers should also be very frank with supporters of these politicians, because it's the lawyers who have really been, misleading both the deputy president and the supporters. It's very wrong, because we are going to have a lot of hopes. Some of the supporters of DP are going to have a lot of hopes, and they are really peddling a lot of propaganda, a lot of rumors, which are very baseless, that the DP is still the DP and it can still be reinstated. That one, if it were not a political process, then you would say that it could be reinstated. But this is a political process, and it is as good as it is done. Thank you so much for the opportunity.
Thank you, Mzalendo, for your sentiments. And indeed, a lot of people also tend to agree with you. A lot of people disagree with you. And the lawyers are here. I see them lined up. And Willis Otieno has also been the sidelines for a while. I have heard his arguments. I'd like the people who are participating in this also to benefit from his side and his view on all this. For the last 3 days, we have engaged, and he has his own perspective. So, Willis, I'll give you your time also to reflect on what exactly is happening. And tonight it's legal and or political. And I saw your argument with Professor Ojenda also. And obviously, there's a lot of interest in this topic going forward now that the courts decided to put everything on ice until Tuesday. But start with what will happen on 29th, what is supposed to happen on 24th, what is supposed to happen on 22nd, and the referral of this case to the 3-judge bench. What does that mean? So paint that for us first, then you can also contribute to this discourse. Is he former impeached deputy president, or is he still the substantive deputy president until this case is completely adjudicated? Willis. Willis just signed out like that. Benji, you've been quiet for 47 minutes straight. I want your reflection. Then we'll find a way of giving Ochieng Odongo an opportunity also to speak. But Okachi, you've been quiet for a while. I'd like to know what you think, having had all that contribution.
Ken, I didn't realize 47 minutes because listening is also a skill. In communication, listening is as important as speaking. I've really enjoyed listening to Professor Ojwang. He's a brilliant mind. I've always enjoyed, especially during the elections, just hearing his perspective and his angle. He's always a bit different and unique. Oria, I can't remember his other name, but Oria made a very fantastic point. He spoke on values and the need for decency in our politics. It was such a fundamental point. Indeed, political power, I always tell people that P equals P equals P. Politics equals policy equals people. Everything that we do in politics is really null and void if it is not for the benefit of the people, if it is not for better policies that then improve people's lives. And so it is important, as Oria says, to never lose sight of the fact that politics is about service. Why do we run for office in the first place? Is it just to be doing tenders with KEMSA? Is it to benefit your own sons, as we were told by the former deputy president? Or is it for the greater good? Is it to improve this country, to move it towards Vision 2030 and beyond? And so there's a need for decency. And as we talk about that decency, Ken, I just wanted to say that courts must have a a tradition of being minimalist in general. Indeed, I've had the discussion and the argument here that if somebody is fired from their job, they should be able to go to court. Yes, that is true. If they feel their rights have been violated, sometimes you're discriminated against. Other times, your boss just wants to cut your pay and those kinds of human resource things. You should have recourse in court, absolutely. But this is a slightly different case. This is not just a job. This is the second most powerful office in the land. This is a political office. This is an office that came about out of a political process. The president nominated Rigathi Gachagua back then as his running mate. That's how Rigathi Gachagua became deputy president. Conceivably, the president feels now that he cannot work with this particular deputy president. In fact, Ken, allow me to say that just from listening to different, contributors on this forum, if Ruto was insincere, and I'm just surmising from different things I'm picking, if Ruto was insincere, he wouldn't want a deputy president. Come to think of it, he wouldn't want a deputy president. If Ruto was not sincere, he would be trying to find angles and, legal interpretations that allow him to be the one at the helm without a deputy. But what did he do instead? He has moved quickly to shore up that gap and that vacuum by nominating a man that he feels he knows well and trusts and that he can work with. Because it would be another story now if, like in the VP Saitoti days, God rest his soul, Moi went out of VP for a long time. And when people asked, he said, it's not important because it doesn't add an extra sufuria of ugali on your table. So for me, in all this, Ruto is not suspect. What my sense is, my feeling, Ken, is that there's a huge agenda for the government. There's huge expectations. There's many, many, many challenges. A lot of projects have stalled. There's fiscal issues within government, the delicate relationship with IMF, and on loans because of the borrowing that happened under Uhuru. That's just a fact. And so if you're working at cross purposes, it can never work. That's just my feeling that if you're working at cross purposes, that can just really never work. And so maybe the last point I'd like to make is, the lawyer Duncan, the other Duncan Okach, who was explaining that the High Court order was a reversal. A conservative order is a freeze. Like there was a whole elaborate process, and now the court came in and looked at what was happening and listened to the pleadings and said, okay, wait a minute, let's just pause. Let us freeze the process at this point so we can make an evaluation and then we'll revisit. That's my understanding. There's nothing here like vacating or overturning. It's not the same thing as what happened in 2017 when the Supreme Court looked at the evidence, numbers were not adding up, said that there were issues and irregularities and illegalities and process issues, and then overturned the result. That's different. That's at the Supreme Court level. At this level here, as a conservative order just says, okay, let's just hold on a second. Let's pause. Let's take a look. Let me hear the parties, inter parties, for instance, and then we will make a summary judgment. A summary judgment which then can still be appealed in the Court of Appeal. Again, I've warned about this country becoming an overly legalistic society where there's so much legalese under this Constitution 2010. Anybody and everybody can go to court for anything. So I urge caution. I urge that we try to be very objective and always to unite the country to avoid, anarchy. But I also must express my reservations on why the former deputy president just wants to cling to office by force. It's that, Ken, if maybe you could help me understand, that has never made any sense to me. The minute it's dysfunctional, things are not working. This is a political office. Inside of a political process, you guys are in a party, UDA, Kenya Kwanza Coalition. You feel a certain way about Mudavadi's so-called shares or whatever. You're unwanted. And you yourself, let us not also argue in the context of defending the constitution. A lot of people who are defending it, they're kind of making Rigathi Gachagua look innocent. Gachagua is not innocent. Gachagua is a tribalist. Gachagua is toxic. He's been, and repeatedly, he's been advocating against other communities. In fact, I just saw video earlier today where I was just looking to see what we will discuss on this show this evening, Ken. A video of Gachagua just lambasting the former prime minister in front of the president, using unpalatable language and actually issuing threats during finance bill, saying that parts that did not vote for the finance bill or that expressed dissatisfaction with the bill shouldn't have roads. I mean, I think he just never read the Constitution. I've said this and I'll say it again. Gachagua never understood the Constitution of Kenya 2010. There's no way you can tell me a deputy president can stand on a platform and say that there are people in Kenya who have no shares. That is unforgivable. I don't even know how he survived 2 months after making such a statement, and went further to make the statement again, including in vernacular and in Swahili. So it's not like he's innocent. We reached this point because Gachagua made his bed and then he lay in it. The process went through the National Assembly. It went through the Senate. Those are just statements of fact. What I'm surprised is that a judge had the temerity to rush to stop such a delicate and weighty process. Perhaps I might concede that it looked a bit high speed. Maybe it could have waited a day or two. But then again, here's a situation, Ken, where Gashagua's own legal team concedes an hour after they've broken for lunch that they don't know where he is. Doesn't that smack of trickery to you? That's what Muita said. We're trying to get a hold of him. We don't know where he is. And then you expect me to just believe that he's unwell and admitted in hospital? Come on. Mchezo wa tauni. Asante.
Asante Benji. I see our time. We have about some few minutes with this. We have had a lot of discussions on this. Professor Ochieng Odongo, perhaps take 2 minutes, then Joe Asali, then Dan Chapter, then we can close this for tonight. Let me see how many more people want to join, but let's go with Ochieng Odongo, just about 2 minutes. Joe
Thank you.
Asali, and then we can give back.
Thank you so much. Thank you so
Yeah.
much, Ken. I think mine would even probably take less than 2 minutes. I just wanted us to be a bit more objective. I know, this issue has elicited a lot of reactions from the public. Some of us, of course, have a stand. Some of us don't like Gachagua. Some of us like him. But on matters such as this, I think the most important thing is to let the Constitution have its way. So if somebody then comes and begin to say that, there were those orders from the court, but because, you want to cite so many things, then Kindiki is a president, I don't know, deputy president elect, and Gachagua is not. Is not a DP. I think that is misleading Kenyans. So I think the focus should be where we find ourselves now is, it's a situation where which according to me is very simple and that is very basic, because when the courts have spoken, whether you like whatever it is that they are speaking to or not, ours is to comply. And to this level, therefore, the courts have not even said if the process were not followed or not. What they have done is to issue those, what we call those conservatory orders. And I was talking to a lawyer friend of mine, and what lawyers say is that, conservatory orders are not just mere injunctions. They are even different from stay orders, so that they are very comprehensive enough to the extent that they can actually even stop things which are yet to happen in the future. They can also then stop things which have happened. So to that extent, therefore, we have Gachagua as our DP. It is not something that most of us like, but that's the reality. So, it is also important to note that where it is now, Tuesday is not very far. That is when then we should be able to know what the courts will then say. But if we try to act with emotions and probably try to bulldoze the courts, some of these things will use in the future. And courts are very, very, very interesting people, because what happens is that a judgment that is passed today, if it is bulldozed through emotions and whatnot, it can then be cited next time. And that next time it will be a Ken Mijungu that is the DP in question. So let us just have and let the courts and the judges do their work. Thank you.
Can I had a right of reply?
Yes, Duncan, you have would you want Joe Asali to go? Then you can have your right of reply. Okay, Joe Asali. Thank you, Professor Ochengo Dogo. Asali? Oh, he's not here. So Dan Chapter, are you here?
Yes, can you hear me? Yes, I'm here.
Yeah, you go ahead.
Oh, I think by now we have
Let's go ahead.
Can you hear me? Can you hear me?
Yeah, but your network is not clear.
Okay, but you can hear me now.
Yes, we can.
Okay, what I'm trying to say now is this: in Kenya politics, it's very difficult to decide between today or tomorrow. We have to give it time, because if we keep trusting court will never work in Kenya. Uh, Politicians are the one who are arranging what's happening in Kenya. Now we have a big problem. William Ruto control everything, controls the courts, control the police. As a country, we only have Ruto. Now he has a big part to play. We don't have anything to do with judiciary. Kashako is going now. Kindik is coming. Kindik cannot say anything. We don't have deputy president. We only have William Ruto. Everything is William Ruto. That's what I can say by now.
Okay, that's it. Okay, that's it. Okay, so Joe, are you here? Joe is not here. So Dan, you can go with your right of response. Then we can see when to end this. I hope people are tuning in. I don't even know if some are just coming in and we are tuning out. But Okach, it's your time now. Anyone who can hear me?